In this series of videos on drafting, pleading and appearances, let us look at the procedural aspects of working of the civil courts. If you have not yet subscribed to our channel, kindly subscribe to our channel, and if you like the video, kindly press the like button and also share it with your friends. Now, if at all you have got some sort of dispute, let us assume that it happens to be a civil dispute, then naturally you will have to file a petition. We call it as a plaint before the civil court. And then the civil court will take up the matter, it will call the other party, that is the defendant, and then the other party would come before the before the civil court, and then he will come out with his own defenses, and I would be having my own defenses. Then the court will see whether my defense is valid or else the defense of the defendant is valid, and then it will decide who is the wrongdoer, and then the wrongdoer would be punished. That is, there could be a penalty, or else if it happens to be a money suit, it will say that you are supposed to return back the amount. Now, how do we file a petition before the civil court, or what is the petition that we file before a civil court is called as? Before that, first we will have to understand this concept of jurisdiction. Like for example, if it happens to be a criminal case, you cannot file it before a civil court. If it happens to be a civil dispute or else a litigation, actually you cannot file it before a criminal court. So for that you will have to understand the jurisdiction. Now, jurisdiction could be divided into territorial jurisdiction, or else it could be a pecuniary jurisdiction, or else it could be a subject matter jurisdiction. Like subject matter jurisdiction, which we have already seen. Like if it is a civil matter, then you cannot file it before a criminal court, and if it happens to be a criminal matter, naturally you cannot file it before a civil court. If it happens to be a consumer dispute, you cannot take it to the regular court, naturally you will have to file it before a consumer forum. Now, what is this territorial jurisdiction? Now, let us assume that both the parties to the dispute, like the plaintiff as well as the defendant, they reside in Delhi. Naturally, they cannot file a suit in Bangalore, because what is the subject matter, where the litigants are residing, both the litigants are residing in Delhi. Naturally, they cannot take it to the court in Bangalore. So, this we call it as a territorial jurisdiction. If at all there is a dispute in Bangalore and both the parties to the dispute reside in Bangalore, or else they carry on their business in Bangalore, then they cannot naturally take it to Bombay. Now, that happens to be the territorial jurisdiction. So, first what you will have to see is whether the court has got the jurisdiction to entertain a particular petition. So, for that you will have to see whether the territorial jurisdiction concept is satisfied. Next is pecuniary jurisdiction. Pecuniary is in terms of money. Like you people would have studied in Consumer Protection Act that if at all the dispute is with respect to the money involved in a consumer dispute, and the money that is involved is 20 lakh rupees or up to 20 lakh rupees, then it has to be filed before a district forum. And if it is more than 20 lakh rupees and up to 1 crore rupees, then you can file it before a state forum. And if it is more than 1 crore rupees, naturally you can file it before the central forum. Now, if the matter is, let us assume, including the compensation in a consumer dispute, let us assume the pecuniary or else the money that is involved is only 10 lakh rupees, directly you cannot take it to the state forum, or else you cannot take it to the central forum. So, first you will have to file it before the district forum. This we call it as, first you will have to exhaust the local remedies. Just because you know the commissioner of police, directly you cannot go and file a complaint before the commissioner of police. First you will have to file a complaint before the territorial, the police station, the police station within which you reside. And then if the matter is very serious, or if at all the requirement of commissioner or the deputy superintendent of police or SP is required, then they will pass it on to the superintendent. Similarly, here you cannot directly file it to the Supreme Court. Directly you cannot file a matter before the High Court. So, first you will have to exhaust the local remedies. Now, let us assume that you have got a very small dispute, then you file it before the civil court in your district. And after that, if you are not satisfied with the decision that has been given by that particular court, then you take it to the higher court, maybe to the senior division court. And then again, if you are not satisfied with the decision that has been given by the judge of the senior division, then you take it to the district court. We call it as a sessions court if it happens to be a criminal case, and you call it as a district court if it happens to be a civil case. And again, you are not satisfied with the decision that has been given by the district court, then you take it to the high court. And once you are not satisfied with the decision that has been given by the high court, then naturally you can prefer an appeal to the Supreme Court. Now, just because you feel that the matter is very important, directly you cannot take it to the High Court, or else you cannot take it to the Supreme Court, unless it happens to be a writ. Writ, of course, we have studied in Constitution. There are 5 writs: writ of certiorari, mandamus, and the habeas corpus, etc., etc. Those things, yes, of course, the Constitution very clearly says that if at all your fundamental right is abridged, then naturally you can take it to the Supreme Court or else to the High Court, as the case may be. And as far as the writ petition is concerned, the High Court has much more jurisdiction or much more power when compared to the Supreme Court, because the Constitution says that if your fundamental right is abridged or any other right, here the rule of ejusdem generis will have to be applied, and you will have to look at what is that any other right is abridged, then naturally you can take it to the High Court. Whereas if it is only the fundamental right is abridged or violated, naturally you can take it before the Supreme Court. Now we have understood what is this concept of jurisdiction. Then let us see, now you are filing a suit. Now when you are filing a suit we use the term for a civil case. The term we use for a criminal cases, we say that we have filed a complaint. So whenever I say suit, it simply means that you are filing a civil case. Now the person who files a suit is called as the plaintiff. So naturally the document that he files is called as the plaint. So he will prepare the plaint, that is the person, the litigant, the dominant litigant, we call him as a dominant litigant. The dominant litigant will prepare the plaint. How to prepare the plaint? Of course, the certain rules are there which is given under the Civil Procedure Code, and then the rules thereunder. So we prepare the plaint in that particular manner, and then we present it before the court. Now the court takes up the matter, and then it will decide to call the defendant. So this calling of defendant is called as summoning. So the court will summon the defendant, because the defendant is supposed to know that a particular case has been filed case has been filed against him. So then the defendant would come, and then he will give a written representation saying that whatever the allegations that have been made by the plaintiff in his plaint is not correct. Now this representation or the written representation which is being filed by the defendant, we call it as a written statement. When I was doing my LLB, I had a doubt whether it is plaint means whether in written, since he is filing a statement, whether it is written R-E-T-U-R-N. It is not R-E-T-U-R-N, but it is actually W-R-I-T-T-E-N. So because plaint is also a written document, then what is the need for them to say that it is a written statement? It is not like an oral statement, but that is how it is defined. It says that you are giving a written statement. So the document that is being filed by the defendant in his defense is called as a written statement. So now the court has the document that has been filed by the plaintiff, and the court also has got the document that has been filed by the defendant. Now the court will look at both the documents. Now let us say that X is saying, X happens to be the plaintiff and Y happens to be the defendant. The plaintiff is saying that defendant is supposed to give me 10,000 rupees. The defendant is saying that I don't have to give any amount to plaintiff. So it means that there is a dispute. Now this dispute, we call it as an issue. The court would frame the issues. That is, what is the question that has to be decided by the court, that we call it as an issue. That we call it as framing of issues. So looking at the questions that has been raised by the plaintiff and looking at the defenses or the answers that has been given by the defendant, the court would frame the issues. And the plaintiff has come to the court, and then the defendant has come to the court. So and they have given their representations, and the court is framing the issues. That is, the court will decide on what are the questions on which I am supposed to give my judgment. Now once both the parties have come to the court with their written representations, then there would be an examination in chief. That is, if I am the plaintiff and I have appointed an advocate, my advocate would put me in the witness box and he will ask me questions. Here you will have to understand that it is my own advocate who is asking me the questions. So this we call it as an examination in chief. Similarly, the defendant would the defendant's advocate would put the defendant into the witness box and he will be asking him the questions like, why you have filed this suit, why do you think that the plaintiff will have, he has done a mistake, why do you say that he has done, he has given a false statement, etc., etc. So the plaintiff's advocate asking the question to the plaintiff and the defendant's advocate asking the questions to the defendant is called as examination in chief. Next, there would be a reversal. That is, the plaintiff would be questioned by the defendant and then the defendant's advocate, and then the defendant would be questioned by the plaintiff's advocate. Now this is called as cross-examination. That is, we are trying to elicit why the defendant's advocate would be trying to elicit why the plaintiff has alleged whatever he has alleged in the plaint, and the plaintiff's advocate would be trying to get the truth from the defendant. That we call it as a cross-examination. Now by this time the court will have a clear idea like what is the dispute, and then whether the plaintiff is telling the truth or else the defendant is telling the truth. Naturally they would have given their documents in they would have given the documents in their defenses. All these things would have happened. Next, what is the court supposed to do? then merely based on the documents and then merely based on the examination in chief and the cross examination, the court will not arrive at the decision. They will give an opportunity to the advocate to put forth their contentions. Now, this we call it as the argument, where they say that a particular piece of section will have to be interpreted this way, and then the defendant's advocate says that no, that is not the right way of interpretation, and then he will say why the plaintiff will have to get the money. Then the defendant may say that no, he is not entitled to get the money. All these things, whatever they have pleaded, those things in a very clear manner, they will try to explain it to the judge. Now, that we call it as the argument. Now, this is the procedure how you actually file it before a civil court. So, first thing is the plaintiff will file a suit, and the document by which he files a suit is called as a plaint, and then the defendant would come out with a certain defenses. Before that, the court would call the defendant to come out with the defenses through a document, and that document is called as a summons. Now, the defendant is coming out with certain defenses or else allegations against the plaintiff, and that we call it as a written statement. Now, based on the plaint and the written statement, the court would be trying to find out what are the questions that the court is supposed to decide, and that we call it as framing of issues. And after that, there would be an examination in chief, that is the plaintiff's advocate questioning the plaintiff, and then the defendant advocate questioning the defendant. That we call it as a examination in chief, and then the plaintiff's advocate questioning the defendant, and then the defendant's advocate questioning the plaintiff. That we call it as cross examination. Then based on all these things, then there would be an opportunity for the respective advocates to present their case. Now, that we call it as an argument. Based on all these things, the court would come out with a decision. Now, that decision we call it as a judgment. If it happens to be an interlocutory application, we call it as an IA. That is, now let us assume from the start of the case till the end of the case, there could be points or time where certain orders are required from the court. Like, let us assume there is a dispute with respect to a particular property. The defendant is afraid, or the plaintiff is afraid, that in the meanwhile, that is even before the court decides on the dispute, the defendant might sell the property. So, what the plaintiff would do is he will file an interlocutory application. That is, you can also call it as an interim application, requesting the court to grant a temporary injunction order. So, this we call it as an interlocutory application or else an interim application. And if a decision is given on this particular IA, that is interlocutory application or else an interim application, that you don't call it as a judgment, but merely you call it as an order. So, the final decision that is given with respect to a particular suit, that we call it as a judgment. Now, just because a judgment is given, it does not mean that the case is over. Now, what is the next step? The next step, the judgment would consider, or it would consist of a decree. Now, decree in simple terms, we can say that it is the executable part of a judgment. That is, the court would say why it has arrived at that particular judgment. You are not going to execute all those things. You will take out only that portion of the judgment which is executable. That is, the court would say that the defendant is supposed to give 10,000 rupees to the plaintiff. So, that becomes the executable portion. So, that executable portion of the judgment is called as the decree. Now, just because the court says that the defendant is supposed to give 10,000 rupees to the plaintiff, naturally the defendant will not give that 10,000 rupees. So, now what is the next step? The next step is you will have to, if the defendant does not give the amount, then you will have to go and execute it. How do you execute it? If you will have to see whether he has got movable property, immovable property, or if his salary can be attached. That is, you execute the judgment. That is, you execute the executable part of the judgment. That is, you actually execute the decree. Now, this is how the civil court actually works. If you want to learn more about the subject drafting, pleading and appearances, kindly fill the Google form given in the description box below. If you have got any comments or questions, kindly leave it in the comment section below. For more courses from Ekcel Academy, kindly visit excelacademy.com.